Hello, everyone. It is my great pleasure to be here today online, if nothing else, with one of the fundamental questions of EU civil procedure in civil and commercial matters. I would like to thank first for the invitation, and then also to the previous speakers, Vesna in particular, for introducing my topic already. So I don't actually need to go into as many details to explain the context in which the topical notions appear. It suffices to say that that lis pendens is one of the crucial elements in coordinating parallel proceedings in different member states. I would like now to share the screen, question of the interpretation, which is actually related to the situation in which we have different notions in different languages. So the versions of the legal texts in EU are not the same. In such situations, the Court of Justice gave some instruction as to how to proceed in interpreting that. So the first instruction is that when EU legislation is drafted in several languages, all those languages are equally authentic if those are official languages of the EU. In that situation, the second instruction tells us that we need to compare the different language versions. In that comparison, we have to make sure that we understand that not all terms in EU law, in fact, many of them, have the Euro-autonomous definition. And lastly, in doing this exercise of interpretation, we need to make sure that the interpretation is a contextual and a logical, taking account of the context and objectives of the specific legal act. So if we turn to the next slide, we can see that regulation, Brussels I bis regulation, as many others, have 24 different legal language versions. That means that it is necessary to go into the exercise of interpretation. So in the next slide, I'm trying to refer you to the first step. So let's look at the Brussels Convention. Perhaps something historical can also be of help. It was drafted, drawn up, drafted in 1968. And the original languages back then were Dutch, French, German, and Italian. And of course, all 4 texts were equally authentic, just as 24 texts today are. But if we look at the structure of these different texts, we see that already from the very beginning, there was no uniformity in the language of this provision of Article 29. So next slide shows us how this is distributed among different language versions. I haven't included all the language versions, most of them, but you can see that, for example, these single notion versions, which include only the same cause of action and equivalents in different languages, include English, German, Croatian, Swedish, Bulgarian, Slovakian, Polish, Slovenian, Portuguese. So it is not a short list. At the beginning, it was just the German language from the original 4 official languages. The next slide shows us the double notion versions of Article 29.1. And this is in French, in Italian, in Spanish, in Dutch, in Romanian, in Latvian and Lithuanian. And please correct me if I somehow got something wrong, because I was trying to make the list as exhaustive as possible in a view of my language knowledge restrictions. Therefore, we can see that the single notion versions contain the same cause of action, while the double notion versions contain le même objet et la même cause in French, or in other, or the same cause of action and the same object or the same subject matter, depends from case to case. Can we then make a conclusion about the fact, is it one or two conditions? So now we can move on to the other slide, where we can see that it's been suggested in the literature that two conditions actually boil down to a single condition, because the one of those conditions matters only, and that is the same object or the same subject matter, as it is sometimes called as well. So could we go to the next slide, please? It's a bit of embarrassment right now, but I hope that you don't mind. Therefore, the question is whether we have two different conditions or just a single one. So one is actually obsolete as suggested. Let's go into a bit of details. If we turn to the next slide, we see that what makes the same cause of action in the Court of Justice case law. In Tatry case, it is the same it is the shipping contract, which are separate but actually identical in their terms and conditions, and the fact that the contamination of the cargo of soya oil occurred because of the problems during the transportation. And in Gubish versus Palumbo, which was already mentioned as well, is that the same contractual relationship makes the same cause of action. So we see where the cause of action stands. However, if we go to the next slide, we'll see that when the court refers to the same object, it speaks of something different. It says action for enforcement of the contract is the same as the action for rescission or discharge of the contract. There is identity. There is also identity in Tatry case between action for damages and action for declaration of non-liability. And there are some other examples from national case law. We can further see on the next slide that what is not included is, for example, the claim for limitation of liability and action for damages in case Maersk, where the court said, oh no, we here have the plaintiff in the claim for limitation of liability relying not on the same piece of legislation as the claimant in the action for damages. Therefore, the next slide can tell us that when we go into the interpretation, even though the German version, for example, and other versions do not expressly distinguish between the terms of subject matter and cause of action, it has to be construed in the manner as other language versions. That's on the next slide, please. And many of those make that distinction. It should be noticed also that the English version of Article 21 also does not expressly distinguish that. And the distinction has to be made, court says, also in case Tatry case. So we've been rushing a bit to the next slide. And from these court statements, which seem to be very clear, we cannot say that we have one requirement. We have actually two distinct requirements. One is the same cause of action that relates to the same legal and factual basis, while the same object relates to the same end of action, and the action has in view, sorry, the end which the action has in view. Only if we have both satisfied, we can speak of subjective identity. Indeed, it may happen in many cases that once we test whether the condition on the same object is fulfilled, that condition on the same cause of action will be fulfilled as well. However, question is it a necessary thing, as suggested in the literature, that practically there is only one requirement in practice? It is submitted here that we should not simplify the scheme as much. It's not as simple. I have tried to come up with the situation in which we can talk about in this context. And in Mark's case, the question was actually whether the application by a ship owner who seeks to have the liability limitation fund established under the convention is same as the action for damages under the national rules on torts in maritime disputes. And the court said, no, it's not the same because of the difference of the legal basis. However, we can also, what if we vary one element of the case and imagine that we have a declaration of non-liability under some international convention? Thus the claims would have the same object as in Tatry, but not the same legal and factual basis, or not, maybe. However, the legal basis for discharge of the contract would be different from the law on which payment is sought, which would be civil code, but it would be based on a particular convention. And in that case, we can make the analogy with the Maersk decision. So would that be equivalent to the Maersk decision or not? That is something that has not been resolved in the case law. And however, I don't think that we need particularly to worry about these matters of interrelation between the requirements, because in my opinion, as I see it, these requirements are set as cumulative, separate and cumulative. Although, of course, in judging them, we will think about the same context, the same two different or the same situation of two parallel proceedings. If we move to the slide which is next, then we can somehow make the conclusions on the interpretation and say that we do have different language versions. They can be compared, and that reveals that we have in the case law of the Court of Justice interpretation of the different language versions. We see that it's cumulative requirements. They enjoy the autonomous interpretation in the EU law, and when in the context of Brussels I regulation, when we need to take the whole system in account, we need to think of the maintaining and developing of an area of freedom, security, and justice by, for example, facilitating access to justice and principle of mutual recognition, stressed in Recital 3, as well as objective to attain harmonious administration of justice by minimizing the possibility of concurrent proceedings and ensuring that irreconcilable judgments are not given effect in different member states, according to Recital 21. Thus, this rule in Article 29 and its pendants as a whole is a part of three-tier system which assures stability of the regulation on three levels. Yes, the first being the special jurisdiction by attraction, the second being the less pendants and related action, and the last one, the rules on refusing recognition on the grounds of res judicata. We already heard it's connecting. For all these reasons and the context in which it stands, I think we should not go into simplifying things, but read the Court of Justice decisions as they are, specifically distinguishing the two requirements and entailing both of them have to be met. Thank you very much for your attention.